For the record, Your Honour, my name is Thompson, initials HF, and I appear on behalf of Johnny Wishbone as his defence counsel. Mr. Wishbone has been indicted on 106 charges. However, I will be making submissions that, due to several violations by the arresting and interviewing officers of their legislative obligations, these charges have no evidential basis on which the prosecution may pursue my client. I will then be requesting, Your Honour, that you make a ruling to exclude both the officer's notes and the recorded interview, pursuant to Section 590 AA, subsection 2E of the Criminal Code. Before entering my submissions, Your Honour, I would like to quickly go through the salient facts and inform the court of the nature of my application. Mr. Wishbone, who is a Torres Strait Islander teenage boy born 29 June 2000, making him 16 years old, was approached and questioned by two officers in an unmarked patrol car at a property in suburbia. Without identifying themselves, they briefly questioned my client, searched his backpack, and found some property they believed to be stolen. They then proceeded to arrest my client for breaking and entering and stealing. Directly following my client's arrest, the officers began to drive my client around suburbia, pointing at various properties they were aware had been burgled, and questioning my client whether he had perpetrated the burglary. Looking at the officers' notes, they have written down that they questioned my client in this manner 3 times, to which my client replied in the affirmative each time. I am unaware whether any written notes were taken down for the remaining 101 times this line of questioning must have been undertaken, and an admission was made by my client for the police to have ended up with 106 total charges against him. Finally, my client was taken to the police station in the city and was provided a support person, not of his choosing, who was completely alien and unknown to him, and who told him to answer the officer's questions. The police then recorded this interview and obtained full admissions from my client in relation to all 106 charges. Now, Your Honour, I will begin my submissions by referring to Section 421 of the Police Powers and Responsibilities Act, herein referred to as the PPRA. This section applies where a police officer wants to question a relevant person, in this case my client, and the officer reasonably suspects that the person is a child. The meaning of child for the purposes of this section can be found in the Schedule 4 Dictionary of the Youth Justice Act, to which I refer, Your Honour, now, which states a child is a person who has not yet turned 17 years of age. Therefore, this section ought to have applied not just during the recorded interview, nor just during the police driving around and questioning my client, or finally, just at the scene of the initial alleged crime when the police began questioning him, but at every one of these occasions. Subsection 2 of this section states an officer must not question the child unless the officer has, if practicable, allowed the child to speak to a support person of his or her choosing in circumstances in which the conversation will not be overheard. Considering that my client and his parents live in suburbia, it is difficult to see how it would not have been practicable for the officers to have allowed Mr. Wishbone to speak to his parents or any other potential support person at any point in time, but particularly at the scene of the initial alleged offence and whilst driving around suburbia itself. Whilst the support person may have been offered at the police station before the recorded interview, this person was unknown to my client and certainly not of his choosing. This, Your Honour, is the first act by the officers in contravention of the PPRA. The next erroneous act comes about due to the officer's failure to inform my client of his right to communicate with a friend, relative or lawyer pursuant to Section 418 of the PPRA and Schedule 9, Section 23 of the Police Powers and Responsibilities Regulation, herein referred to as the PPRR. Consequently, this failure to inform my client precluded him the opportunity to communicate with a person who he may very well have chosen to be his support person during the recorded interview, the one in which he admitted to the commission of all 106 offences he'd been charged with. This, Your Honour, is the second act in contravention of both the PPRA and PPRR by the officers. Finally, because of these violations, my client has been placed in a position where he's been given no support from a chosen legal guardian, friend or lawyer, and the support person he has been given has made an incredibly damaging statement by asking my client to answer the officer's questions, the effect of which will be discussed below in my submissions in relation to the sought order. If the officers had complied with their obligations under Section 34 of the PPRR, specifically subsection 2C, in providing the support person with a statement telling them that they ought to ask my client questions to ensure that he understood he's not obliged to say anything during questioning, she may never have made this detrimental contribution. This, Your Honour, is the final act by the officers in contravention of the PPRR I will be submitting in relation to. Therefore, I would seek orders from Your Honour that in line with concepts of fairness mentioned in Section 130 of the Queensland Evidence Act, and the Court's inherent discretion to exclude evidence, in line with either the principles formulated in the case of Regina and Christie or Regina and Ireland, that both the recorded interview and the police notes be excluded. In relation to the Court's exclusionary fairness discretion, I would submit that any admission by my client, whether written in the officer's notes or stated in the recorded interview, are of little probative value. This is due to his status as a Torres Strait Islander youth and his obvious use of gratuitous concurrence, an Indigenous cultural phenomenon in which he answered in the affirmative even though he may not have agreed, without recognising the significance of these perceived admissions. This was done out of a desire to be seen as being amenable by the officers and to build a relationship with them, not to signify agreement. Therefore, given the largely prejudicial effect this evidence may have on my client, compared with its little probative value, I submit it is well within the Court's power to exercise its exclusionary fairness discretion. In relation to the Court's exclusionary public policy discretion, more recently applied in the case of Bunning and Cross, I would submit that the arresting and interviewing officers have deliberately breached their statutory obligations under the PPRR and PPRA. There is no excuse, such as genuine mistake, available to them, as my client was clearly identifiable as a Torres Strait Islander youth. Furthermore, these breaches are in clear violation of one of the express purposes of the PPRA, which, if I may direct Your Honour to, Section 5, subsection E, is to ensure fairness to and protect the rights of persons against whom police officers exercise powers. Therefore, I submit it is well within the Court's power to also exercise its exclusionary public policy discretion. That concludes my submissions, Your Honour.